Hey everyone, Angela Langlotz, trademark and business law attorney here. I'm also live on Instagram, so you can follow me there. I have videos there as well. You can also like my Facebook page, and I answer questions that people post on my Facebook page. It's facebook.com/trademarkdoctor. And I am on the internet, of course, at TrademarkDoctor.net. Today, I would like to talk about works for hire. So this week, this is copyright week. I haven't traditionally talked about copyright law. I've been mostly focused on trademarks, but intellectual property is copyrights, trademarks, and patents. And so I like to talk about all of those, but I've kind of neglected copyright law. So let's talk about works for hire. Now, copyright law gives creators the right to any work that they create, and you create it and you reduce it to a tangible medium. It's yours and you own it. However, there are a couple of loopholes in that law, let's call them. And one of those is fair use, which we will talk about later. And another one is works for hire. So a work for hire is a creation. Now remember, copyrights cover any creative work that is reduced to a tangible medium. So not ideas, you have to reduce them to a tangible medium. That means you have to write them down or sing them or record them or put them in lights on the Eiffel Tower, whatever. Okay, so that is reduced to a tangible medium. It has to be something that we can see, hear, touch, or smell, or taste, right? So if you are an employee and you work for somebody else, then everything that you create is not yours. You are creating what is a work for hire. So the work for hire means that the person that is your employer owns your creative output while you are working for them. So if the creative output that you're making is part of the scope of your work and you're doing it on the employer's time, then you don't own it. Your employer does. So let's say, for example, that you're hired to produce videos for your employer, but on your lunchtime, you're writing an epic novel. You're using the employer's computer, but it's your novel on your time. And you're not hired to write novels, right? So arguably the novel would be your property, because even though you're on the employer's time and maybe you're using their computer, you're on your lunch break, right? And you're not hired to create that sort of content. You're hired to create videos. And videos and writing the next great American novel, not the same thing. Now, what if you're a contractor? You're an independent contractor, like maybe you write blog articles for people, or you produce videos for people. Who owns that copyright? Well, you need to make sure, if you're creative and you want to make sure that you own the copyright to the things that you produce, you need to set that forth in your agreement, your work agreement with the person who's hiring you to do the work. If you are hiring a creative and you want to retain the rights to the materials that you are hiring that creative to produce for you, then you need to make sure that you're very clear that what you're hiring the creative to do is a work for hire and that they don't have the copyright, you do. So as long as these things are set forth clearly and everyone's on the same page about who owns what, thumbs up. No future conflicts there, at least as far as the copyrights go. So I'm Angela Langlotz. I'm a trademark and business law attorney, and I go live every day here, right here on Facebook, to talk about all of these issues. So if you have a question, message me on my TrademarkDoctor.net page and I will answer it in a future live. Don't forget to like my page because you'll be notified each and every time I go live. So tell me your trademark, patent, or copyright questions and I'll get them answered for you. And I'll see you tomorrow.